Good evening, good afternoon, good morning, everyone. My name's Ben Giaretta. I'm a partner at Fox Williams, and I'm moderating this session, which is on expert witnesses, status, independence, duties, and conflicts. And this is a member-hosted event hosted by 4 Pump Court, Fox Williams, Keating Chambers, Secretariat, and 3 Crowns. And I have to thank our sponsors, who will appear magically on the screen here. I'm not going to read them out, but there they are. And let me just say a bit about who is on the panel today before I describe what we're going to be doing. So first we have Adam Constable QC, who is a silk at Keating Chambers. Adam specializes in onshore and offshore construction engineering, energy, shipbuilding, and technology disputes, along with professional negligence and insurance claims related to those sectors. He's got extensive experience in both litigation in the English courts and in arbitration throughout the world, and he's the editor of Keating on Offshore Construction and Marine Engineering, and the co-author of Litigation in the TCC, amongst a lot of other stuff. But those are the 2 publications that jumped out at me when I looked at his CV. Then we have Don Harvey, who is the founder and managing director of Secretariat International. He has over 25 years experience in the construction industry, managing projects and advising clients on issues involving project and contract administration, claim preparation, delay, cost, disruption, and productivity analysis. He's testified many times as an independent expert witness in litigation in the UK and the US, and in arbitration in many forums across the world. He's been engaged on disputes, some of the most high-profile construction disputes in the world, such as the Panama Canal, Wembley Stadium, and the Burj Khalifa. Thirdly, we have Lynne McCafferty QC, who's a silk at 4 Pump Court. She's got particular expertise in construction and engineering, energy, professional negligence, and technology and telecoms. She's got extensive advocacy experience in the TCC, in the international and domestic arbitration, and adjudication and mediation. She's an advocate in the DIFC, and she's particularly adept and highly experienced in cross-examining expert witnesses in a wide range of disciplines. I took that from her website as well, and I thought that was particularly apt considering the topic today. Todd, finally, we have, last but not least, we have Todd Wetmore, who is a founding partner of 3 Crowns LLP based in Paris. He's practiced in international arbitration for the past 25 years, both as counsel and as arbitrator, and is a recognized specialist in infrastructure and construction disputes. He's qualified in France, England, and Canada, and he's a vice president of the ICC court. So those are our speakers today. Obviously, they've all got much more extensive CVs. I'll leave it to you to go away and look it up on their CVs if you'd like to find out more about them. What we're going to be talking about today is the state of the expert witness industry, if you like, in the modern world, and experts in litigation and arbitration. Now, as we prepared for this session, we have struggled a bit, I must say, to get to grips with this topic, because it's such a big topic. I mean, there's so many different angles to it, so many different aspects to it. At the end, we settled upon 2 broad areas of discussion. The first is about partisanship, or alleged partisanship, amongst party-appointed experts. And the second is about the duties of experts and conflicts of interest. So we're going to run the discussion along those 2 lines, kicking off with partisanship. And I'm going to ask Adam to begin with to introduce the topic of partisanship and explain what the position in the English law is about partisanship.
Sure, thank you. Will do. So it starts, doesn't it, with the IKEA and reefer, all those years ago, 25, 30 years ago. And that set out, for the first time, really the basic principles that all experts should follow. And that was then adopted in the CPR in large part. But as we all know, I think that didn't really resolve the problem. And in fact, in preparation for this seminar, I was surprised by the number of recent authorities there are in which the courts have found themselves having to chastise experts in judgments over their failure to have acted independently. So is it a problem? Yes, it is a problem. It's remaining a problem. And my anecdotal experience, I think, is that for every case where one comes across it in the High Court, one may come across 2 or 3 or more cases in arbitration, where I think under the veil of privacy, clients and their experts might feel a little bit more able to push the boundaries of where the line should be, in the knowledge that they're not going to have a published High Court decision publicly telling the witness off. So I don't want to spend long on them, but just a quick run through of certainly the more recent ones. Before we get to that, there's one from 2002 which is so amusing that it has to be referred to, a case called SPE International versus PPC, where the absence of independence and failure to have carried out proper expert instructions was such that it transpired in cross-examination that the expert's wife had written most of the report. There was an express finding of lack of independence, and the evidence, perhaps unusually, was in fact found to be inadmissible. So it wasn't even a matter of weight. It went to the question of admissibility. Into more recent times, there have been cases every year since 2017 in the TCC where the courts have found it necessary to criticise experts. So starting off with Imperial Chemicals in 2017, that is a case in which Mr. Justice Fraser said, if it were necessary, there are some jurisdictions where partisan expert evidence is the norm. For the avoidance of doubt, this jurisdiction is not one of them. And he went on to set out sort of almost an updated version of the Icarian Reefer, some principles which are good to have to hand if you are seeking to make submissions about the partisan nature of expert evidence, or to have a tool for cross-examination. It's a good checklist. And he found that independence requires an objective consideration by an expert of both sides of the factual evidence. And I think one theme that runs through all of these cases is experts picking and choosing those facts upon which they rely, and not giving an opinion based on the other side's factual scenario. So moving on then, in 2017, there was another case, Reaver Properties versus Foster and Partners, where the expert QS got it in the neck. And again, on a similar theme, it seemed to me the judge's key criticism was that the expert refused to make assumptions. So he refused to price the other side's design solution, saying that for various reasons it was difficult for him to do, which the judge found had no intellectual justification whatsoever and was an approach that verged on nonsense. One good way of spotting partisan behaviour and one good way of preventing it is to make sure that assumptions, the other side's assumptions, are ones that are addressed by your expert. Again, 2017, what a good year for these sort of cases. Another case called Bank of Ireland versus Watts Group. There was an express finding that the expert hadn't been independent and had indeed attempted to mislead the court by omitting relevant parts of quotations. And slightly amusingly, the judge said for him it might be said that the Icarian Reefer was a ship that passed in the night. Moving on to 2018, back to the TCC, Castle Trustee versus Bombay Palace. Again, a nice quote from Mrs. Justice Jefford, who spent a good deal of the judgment dealing with the various experts and said, in a case of fairly remarkable experts, this was the most extraordinary, and referred to a delay expert who had adopted another expert's report, hadn't seen the pleadings or disclosure, and apparently hadn't given a moment's thought to what a realistic baseline program might be, not matters you would hope your delay expert would ever be responsible for. 2019, Bates versus Post Office, obviously a hotly topical case at the moment. That was the litigation, again, it was Mr. Justice Fraser dealing with the Post Office scandal. One would talk about it, about the Horizon, the software, and he had some fairly stern words about the Post Office's expert, who found he had an obvious preference for his own side's evidence, which he described as a particularly egregious failure to maintain the necessary standard of independence. He emphasised, and this is one, again, time and time again, we have to remind ourselves, it's the court's role, not that of an expert, to decide which evidence of fact is accepted and which is not. Rolling on to 2019, Ashley Wild Group versus BCPL, copyright dispute. And in that case, the expert had initially been instructed to identify only evidence which supported one party's case, i.e. to look for similarities in the context of the copyright dispute. He was then instructed as an independent expert for the purposes of the litigation, but didn't then go on to look at any differences or carry out any additional work. And then that takes us up to 2020 with NG Fabricon versus MW High-Tech, in which there was also some criticism of the experts. Perhaps that's a good point for me to hand over to Lynne, who I know was counsel in the case, so I better not steal her thunder in relation to that.
Thanks very much, Adam. Yes, what's interesting about those cases that you've talked about, Adam, is how many of them resulted in criticism of the experts for either disregarding the other side's factual witness evidence or for refusing or failing to give opinions based on assumptions which the court or the judge required in order to assess the case that was being made by the other side. And I think that seems to be quite a common theme through those sorts of cases. The case that you mentioned of mine was a slightly different one, where the expert in that case, we discovered, had lifted whole sections of his expert report from Wikipedia, which was something of a gift for me in cross-examination. But it's very rare, I find, you get anything quite as helpful as that for cross-examination. And obviously what you're usually trying to do is to establish that the expert hasn't given proper regard to your client's factual evidence, witness evidence, and so on. I think one of the really interesting things that's come out of the case, I know we're going to speak about in a bit more detail later on, the company versus Secretariat case, which is sometimes called the XYZ case, is that there, all the judges in the Court of Appeal emphasised, when looking at the duties that were owed by the expert, that the duty that the expert owes to the court, so the overriding duty to be independent and to give their evidence truthfully, is not inconsistent with the duty that the expert owes to the client, the duty of loyalty. But the judges rather saw that as a duty which was very much, those duties were very much interlinked. And so the fact that the expert has to tell the truth is something which is important in looking at their duty to the client, because a truthful, genuine expert who's giving their views in an honest way is of more benefit to the client because they have much more credibility. And I think, it's quite rare actually that you have cases where there's a huge red flag over the expert's evidence. What is more common is that there's just a sense during the oral evidence or sometimes even in the report that the expert is defending their views a bit too robustly, a bit too aggressively, that they are ignoring things that are inconvenient in the other side's evidence. And sometimes it's more of a subconscious thing. And I think what's very helpful for clients is if your expert is willing to concede things when it's appropriate for them to do so, is willing to take an even-handed tone in their evidence and in their report as well, because I think that just plays out so much better with judges and arbitrators. And so I think it's interesting the interlinking of those two duties.
No, that's absolutely right. I mean, I always find sort of one telltale can be during the joint expert process, where often it's the other side, isn't it? Because the other side's expert is being unduly influenced by their lawyers, which clearly is a sign of not being properly independent. Clearly there are issues that lawyers are entitled to get involved in relation to joint reports. It seems to me they're allowed to define boundaries and properly say to an expert that is not an expert issue. For example, that is a question of fact, so you shouldn't be dealing with that in the report. But on matters of true opinion, the lawyers should sort of keep their noses out. And you, I'm sure you've come across this too, but you, as you see travelling drafts, you see something that looks very helpful from the other side's expert by way of agreement that has been obtained when the two experts were there sitting down and reaching agreement. And then magically, before the final version is served, that has been softened, watered down, or removed in a travelling draft. And I suppose the expert, I mean, I'm sure the expert doesn't forget this, but we make a note of that, and that's a good way into cross-examination, because you know what their true view is. And in fact, then when challenged in cross-examination, 9 experts out of 10, or 99, even 100 probably will not tell a lie. They will give you what their true view is when pressed on it. So it seems to me it's quite a short-term tactic to try and hide that from your from your opposing party, because it'll come out anyway, and it'll come out in a slightly sort of unattractive way. It seems to me.
I would pick up on the point Lynne made about partisanship being ultimately self-defeating, and I think I have to agree with that. It seems to me that one of the most important ingredients for a good cross-examination is a bad report. And if there isn't balance in the report, or there's omissions, that's going to be low-hanging fruit on the cross-examination. And it also strikes me that these great examples that Adam's found are ones where ultimately the expert was exposed, so much so that it wound up in the judgment. Maybe the interesting question for us is, what about subtle partisanship that's a little harder to detect, a little harder to catch? One of the questions I was thinking about recently, and I would be interested in others' views, is on instructions to experts. Is there subtle partisanship that creeps in the way one instructs experts, the questions that are posed? And are there times when experts actually, as part of their duties, should look twice at their instructions and say, well, those instructions aren't right for me. They need to change, because otherwise I'm not going to be giving a fair opinion.
Thanks, Todd. I should point out to the audience that we have a Q&A box, and please feel free to ask questions, which I'll pick up on as we go along, and we'll have some time for Q&A at the end as well. At this point, I'd like to come to Don, actually, because Don, at the moment you've had 3 lawyers beat up on experts. Well, politely, of course. I'd like to come to you to get your view on the issues of partisanship or of experts.
Sure. Thanks, Ben. And I'd love to give my perspective as an expert. First of all, I think partisanship is definitely occurs and is out there. So there's no ands, ifs, or buts about that. I think what an expert should do, especially if they're working in an environment with lawyers or a QC that's really pushing you to take a point, is, have that discussion with a client that, if you make one small aggressive point in your report, that's where all the cross-examination is going to be, and it's going to affect your credibility, and you lose all of the other good work that was done. And I think sometimes it's necessary to reinforce that point to the client. And we've told clients, look, you're wasting your money if you want us to make this point, because that's going to be the focus of the cross-examination, and everything else is going to be discarded. So that's something that I think a lot of people understand, some people don't get. I also think the pressure to, to take certain points is different in different locations. And obviously in the UK, there's a heavy focus on independence, which I think is great, but in other parts of the world, you don't have that. I also think sometimes clients don't fully appreciate independence, and especially people that worked on the project, and they have these views in their head and they push and push and push because they think they were right. And so I think you have to have discussions with project types frequently, and make sure that they understand the importance of independence. I also think Lynn brought up a great point about making concessions. We've all been in the hearings where you have the expert that fights till death over certain points. And I think you've really got to, make concessions when necessary to maintain, a reasonable view. What would a reasonable person, what would their opinion be? There's a couple other points I want to talk about, and that's how you deal with witness evidence in particular. I think the panel made some good points on that. And I think witness evidence needs to be treated very carefully. I've seen some experts get criticized for relying on witness evidence too much. I've seen experts get criticized for not relying on it enough. There was a movement out there for a while that, that delay experts shouldn't give any opinions on causation whatsoever. They should just give an opinion on the critical path and let the tribunals and the fact witnesses fight out the facts. So I think there's just a couple points that I think what I would recommend people to do is, when you are relying on witness evidence, include both sides. So if there's competing witness evidence and you're referencing it, I would include, both sides of it. I would also, not put in slabs and slabs of quoting witness evidence, because I think that comes across as, from an expert as advocating the position. So I try to paraphrase it and summarize it and footnote it, but also give both sides. Just a couple of other points that I think, I've probably testified 60 times now. I think, one other thing that I've certainly learned through the years is the less aggressive language in your report, the more effective your report is. And I think a lot of people don't understand that. They want to put, use words like outrageous and things like that. And I just think it's, the less aggressive language, the better. It comes across as much less defensive. On the final point that Todd mentioned on instructions, I think it's a very, a very relevant point. And it's when a client gets stuck on a certain position and they just say, well, I'm instructing you to do this. I think an expert does have an obligation to push back on that if the instruction is ridiculous and it's forcing the outcome, in their opinion. So I think that's something that, you don't see a lot of it. And, sometimes experts hide behind their instructions. And I think, the experts need to step up a little bit in instances and push back on their instructions that are clearly unreasonable instructions.
Thanks, Todd. Sorry, on mute there again. Can I pick up some of the questions in the Q&A, and perhaps I come back to Adam for this. There've been a number of questions about the various techniques that are adopted in arbitrations and litigation to deal with partisanship. I mean, some of the audience have referred to hot tubbing, the joint expert statements, to appointments of court-appointed experts. Adam, what's your view on these various techniques that the processes have adopted?
Yeah, so dealing with court-appointed experts, which I suppose is the most extreme example, or certainly arbitration-appointed experts. So it's very rare that the UK court would appoint its own expert, but certainly arbitral tribunals do, and particularly civil ones do, because it's much more of a way in which civil jurisdiction countries deal with expert evidence in the courts. My own view is there are problems with that, and my own experience is that what tends to happen is the arbitral award becomes a sort of rubber stamping of a third party's view who hasn't been, I suppose they've been appointed according to the rules, but they're not the arbitrator, but they almost become a sort of de facto arbitrator. And there are all sorts of difficult issues that then arise about communications between this very influential individual and the arbitral tribunal, whether that has to be, any of that can be behind closed doors, whether it all has to be open. And I think there is also a real problem when, obviously, if you're on the wrong end of a tribunal expert's decision, the ability properly to challenge it is quite difficult. It rarely leads to a cost saving for the parties, because what tends to happen is the parties instruct their own expert in order effectively to shadow the tribunal expert. So it adds to the cost rather than takes away from the cost. And I think you do, and my own view of this is from being an arbitrator as well as being counsel, I think you do lose something in the process by not having the sort of adversarial challenge of the two parties experts. And I think that's particularly so in relation to technical type issues, as opposed to possibly quantum issues where it's much more likely that you're going to end up with a small number of points of points of principle that divide the parties, that can be easily explored and helpfully explored in a hot tub environment in a sort of constructive way. And what you're really doing is elucidating the issues for the tribunal, and then largely it's a matter of submission really necessary rather than expert evidence. And then you've got the very helpful quantum experts who have processed all the numbers so that you've got this set of numbers if answer A is right, and another set of answers is if number 2 is right. And so it is slightly horses for courses, and I think the more technical the evidence, I think my own view is the more sceptical I am as to whether a sort of single joint approach is helpful to the process. I'm much more relaxed about it on the sort of numbers end of the piece.
Thanks, Adam. I'm going to move the discussion on a bit now to talk about duties and conflicts as well. We've already touched on it a bit, but let's go into that in a bit more detail. I'd like to come to Todd next, but before I do, I just wanted to mention a little bit about the case that Lynne's already mentioned, which was the case that actually involved Secretariat. It was a case that was heard in the English courts recently, and we thought it might be helpful if I just explain what that case was about, it was a case I was involved in as well as Don. In that case, a Secretariat company was engaged to provide expert delay analysis in an arbitration arising from a petrochemical project on behalf of the employer. And another Secretariat company was later approached to provide expert quantum analysis on a different arbitration but arising from the same project, where the employer was on the other side. And the employer applied for an injunction preventing the second instruction. The English High Court granted the injunction, saying the Secretariat companies were in breach of a fiduciary duty. Well, when we got to the Court of Appeal said that there was no fiduciary duty, but it upheld the injunction on the basis of a no conflict clause in the engagement letter in the first arbitration. So I thought it might be quite helpful just to give a very quick summary of what that case was about. And in light of that, I'd like to come over to Todd. Could you give us your views of, well, firstly, of what are the duties of an expert to a court or tribunal and to the parties, and how does conflicts come into this?
Thanks, Ben. Let me first comment on a very pithy and succinct summary of those two cases. It was a perfect setup. Look, there are a number of positive duties that experts owe their clients. For example, they're obliged to perform the work they were retained for. They have a duty of care to perform that work to an appropriate standard in line with their professional standards or their field of expertise. They have a duty of confidentiality, which can be quite crucial insofar as experts can come into possession of privileged information. I think those are all straightforward and controversial. What's perhaps more interesting are the negative duties. That is to say, the duties that the experts do not owe their clients. And to be clear, experts are not required to adopt the opinions that the client wants them to adopt. Experts aren't under any duty that would give the client basically access to a hired gun or to dictate what the expert will say. And it seems to me experts are not required to act solely in the best interests of their client. The opposite is true, where honesty and the expert's duties to the court require the expert to give evidence that's unhelpful to the client. And so this last point really takes us back to a topic that Adam was addressing, the Icarian reefer, and all of these duties that experts owe the courts. And it's useful, just in the context of thinking through the XYZ case, to think about these duties that experts owe to the court. They're supposed to ensure that their work product is independent and free from influence, meaning influence from the lawyers and the client, to give an unbiased opinion and not assume the role of an advocate, not omit any relevant facts when giving an opinion, and to qualify their opinion when it is incomplete or lacking in some aspects of the analysis. And the case law also makes clear that these are the primary duties of the expert. So in broad strokes, if you want to summarize it, experts have a duty to be candid and honest when they're giving their evidence, even if objectively it will not serve the client's interest. Though speaking for myself, it does seem difficult to see how an expert can owe a fiduciary duty of loyalty and thus a requirement to act solely in the best interest of the client, while also being required to act independently with this primary duty to assist the tribunal, including by giving evidence that would be unhelpful to the client's interest. I mean, I won't get into a couple of additional thoughts unless people are interested on fiduciary duty and why it seems inapt. But the more promising ground, I guess, emerged in the Court of Appeal decision about conflict of interest. And in that analysis, I'll leave it to others to share their view, but it seems to me that the right place to start in asking what is a conflict of interest for an expert is to begin by asking the primary question of what are the interests that the expert is meant to serve? Because once you have an idea about that, you can then turn and begin to imagine what might be in conflict with that. You know, if you compare lawyers have to act in the best interest of their clients. So when they have two clients with competing interests, that's a problem. That is the conflict of interest. It can also be a conflict of interest with self-interest. But with experts, they're not required or even permitted to just serve solely the best interest of their client. So it's probably more about their role, which is to give independent evidence. If the expert is taking on roles or interests which are going to undermine their independence and their ability to give an opinion, this would be a logical place for a conflict. So, for example, taking financial stakes in the outcome, so buying shares in the litigants and having a financial interest that way, maybe taking on conflicting mandates which require them to do work which is going to undermine their opinion. All of these things would seem to me to be a conflict of interest. But I know there's lots of views on this, so I should stop there and let others have their view.
Thanks, Todd. And let's come back to Don for his views. Now, Don, Todd has introduced the topic of conflicts, and of course, you and I were involved in the case in the Court of Appeal. And then I'm not asking you to comment on that finding in that case, because I know that you accept that finding. But it's the issue about conflicts in the modern world. I mean, you're the MD of one of the leading expert witness firms, and you have offices all over the world, and you're involved in all sorts of projects all over the world. What's your view of what a conflict is in the modern world?
Ben, I think that's a great question, and I think it's something that when you read the Court of Appeals decision, in my view, I still think that question needs to be flushed out. I think the Court of Appeals decision, the way it read was it's matters of degree. A conflict of interest is a matter of degree. And I think as an industry, we should be able to do a better job of defining it, at least coming up with guidelines on what a conflict of interest was. And let me just take a moment. I know a lot of people are interested in hearing our perspective on XYZ, so I'll give that to you. First of all, as Ben mentioned, I accept the decision. I still disagree that it was a conflict, but I accept the decision. And And I just want to run through a couple points in relation to that so you can see it from my perspective, and then move the conversation on to what I think constructively needs to be done about it. Many of you know who the expert is, the second expert that took the case. I'm not going to mention the name, but he's got a phenomenal reputation. He's one of the top producers in our firm and has an enormous amount of work. He doesn't need additional work, and he didn't take the case because he needed additional work. He took the case because he didn't think it was a conflict of interest. It was a different contract, different disciplines. So it was a delay expert, and a quantum expert. Obviously, the law firm that engaged us didn't think it was a conflict. Otherwise, they wouldn't have engaged us. I think that's a discussion, that always occurs. The QC on the case was obviously comfortable with it. The tribunal, the issue was put in front of the tribunal, and the tribunal was comfortable with it. But obviously, the court in the UK felt it was a conflict. And so, from an expert's perspective, obviously these are, they're pretty confusing issues, and people have different views on them. And I think as an industry, we need to do a better job of coming up with guidelines, so that those can be applied going forward, obviously to avoid situations like this. So, to me, that's where I think the constructive dialogue needs to be, is what is a conflict of interest for an expert? And it's obviously, I think as Todd pointed out, there's differences, from a conflict of interest from a lawyer than for an expert. You obviously have different rules for QCs, in the way they operate. But I think there does need to be, more discussion and coming up with some principles and guidelines about what a conflict of interest is, what it means to an expert.
Thanks, Don. Can I come to Lynne now? I mean, you've already mentioned the Secretariat case, and I'm interested to hear your views on it. But also, I'd like to ask you specifically about the point that Don made there about what the lawyers had said to Secretariat on this during this arbitration case, and how they were happy with it. And also to pick up a question by George Doty in the Q&A saying, are the instructing lawyers responsible for most of the difficulties encountered by expert witnesses? Isn't it the lawyers who are to blame for all of this stuff?
I think those are both excellent questions. I think the thing that's interesting about the Secretariat decision is that in the Court of Appeal, they emphasised that there had not been any authority previously on the particular factual circumstances that had arisen in that case. And a lot of the cases that were discussed were on very different issues. And that suggests that this kind of problem comes up less often than the discussions of the case in the journals and so on since the decision might suggest that this is a particular issue that's come up in this case, but there is not a great deal of guidance, as Don says, in other case law about what would or wouldn't constitute a breach of the duties that are owed by the expert. And of course, that then makes it difficult. And I think you see the difficulty in the fact that, as Don said, a whole team of people were quite happy for the instruction to continue, regardless of the feeling in the claimant's camp that this was a conflict of interest. Whether guidance would assess it would depend on the source of the guidance. We saw in the Secretariat decision that Mr. Justice Coulson did consider some of the guidance that was publicly available, but it said that he didn't give particular weight to it. And there was much more discussion about the case law there than about any guidance. So I think it's difficult in a jurisdiction like ours to develop that kind of guidance that would have enough weight in a court hearing to be able to be relied upon for other experts. As for the question about is it the lawyer's fault? Well, I think certainly the lawyers, there's an emphasis on the lawyers, of course, to direct matters when the question of whether there's a conflict of interest is obviously a legal point, and often comes down, as we saw from the decision, to analysis of the contractual duties. So I think certainly the lawyers do bear a big burden to direct things. But I think one interesting aspect of the relationship between the experts and the lawyers is that the judges in the Court of Appeal acknowledged that the expert is a part of the team, is a part of the legal team, and that they will work together as a team. The client will depend upon the advice that the expert is giving behind the scenes about the strength or weakness of their case on different issues when deciding whether to move forward with the claim or the defence. And so there's a real, there is definitely a difficulty in marrying up that duty with the duty that the expert has to the court. I think that kind of balance is one that the Court of Appeal recognised is difficult. So I think there's no easy answers to this one, unfortunately, but I do think the question that was asked before is quite right, that the lawyers do have to take a big responsibility in directing things and ensuring that nobody's falling on the wrong side of this difficult dividing line.
Thank you, Lynne. I'm going to come to some of the questions. I mean, with questions coming thick and fast here, and I'm not sure we're going to be able to get to them all, but I do want to pick up on a few of them. And in particular, there's a question from David Barry, another well-known expert, of course. And he says, there is no professional reason, is there, why two experts from the same firm couldn't oppose each other in a case, provided, of course, the necessary ethical and confidential screens are deployed. I wonder if I can come to Adam. What's your view on that question?
Well, doesn't it raise the same, I mean, there's sort of distinction that exists between law firms and counsel in that at one level, you know, is there well, one level I can represent client A and someone else can represent client B, and that happens. We share branding, but we are deemed to be self-employed and are self-employed individuals. So the conflict historically hasn't arisen. I mean, the asterisk on that is that it's in certain jurisdictions it isn't understood, and arbitral tribunals don't really allow it. And so even that sort of ability to do that is if it's going in a direction, it's going against the direction of us being allowed to do it. It's going in the direction of closing down the opportunities to do that. Versus, of course, law firms, and you know, where there are occasions where the relationship of a law firm with one party in a transactional part of the company is so completely separated from the litigation aspect in relation to something else that you might get permission and for that not to be regarded as a conflict of interest, but internally it's almost certainly not going to be signed off by the law firms and would cause a problem. And I would have thought the same broad principles will apply to the way in which a court looks at experts, and if they are essentially tied together by a single financial institution, however intellectually capable the individuals are of screening themselves off from their co-worker, it'll be regarded as a conflict. So I in a sense, David, I mean, answering your question, David, I mean, I have sympathy to the view that one can intellectually do it, and particularly if you have got you know, your obligations of independence and to the court, and if those are paramount, then it shouldn't matter. But I'm sceptical that's the way it would be looked at, and I think the recent decision, if anything, is consistent with that. That would be the concern of court.
Thanks, Adam. And I want to come to Todd next. I want to ask the question from Hugo Cesar in a moment, but actually, perhaps you'd like to comment on what Adam has just said there as well, particularly wearing your ICC hat and also being French qualified. Are there any different perspectives from there?
What I was going to say is, in response to David Barry's very good question, is yes, you may be right that professionally there's no limiting principle which would prevent experts from the same shop to be opposing. But you probably have a practical question to confront, which is why is it that experts with the same sorts of expertise from the same shop, who are supposed to be engaged in an honest effort to produce a competent opinion, would wind up opposing each other and being miles apart? You'd expect them to converge and have the same view, which is what infuses my ideas about the XYZ case. I mean, to me, is there a big sin being committed if different people are looking at different aspects of the same project? If they're being rigorous, if they're being honest, if they're competent, you'd expect their opinions to be broadly coherent and compatible. But I mean, that's just my perspective on it. I'm a big believer in rigorous expert opinion being right and sound.
Absolutely. And thanks, Todd. And I want to ask you Hugo Cesar's question as well, which is about it's about the information that experts should give about their clients and their involvement in other projects and other industries in light of these conflicts of interest points. I mean, if, for example, now wearing your hat as a partner 3 Crowns, if you were instructing a company like Secretariat, would you now be asking for them to give information about all the other projects they're involved in case there's a potential conflict?
Yeah, I would not. I mean, I don't think that expert firms need to be treated like law firms. And, you know, the New York conflict rules or the English conflict rules should apply. So I would not be trying to figure out if an expert that I'm hiring is working for or against any particular client somewhere else in the world. For related matters, I might want to know because I'm going to be interested in confidentiality. One interesting question is repeat assignments. Is it a sign that an expert is a hack if they're repeatedly hired by a law firm, or is it a sign that they're simply good? I find it difficult to accept that someone should be criticized because they're hired again after doing a good job.
Well, absolutely. I mean, and this, of course, is an issue in arbitration with arbitrators that comes up again and again. But let's throw that back to Don. I mean, Don, I know that you are appointed again and again. Do you worry that this may lead to criticism of you as being lacking independence?
I think, you know, in many instances, my CV will get pulled out and they'll say, who are you working for here? Or they see a client that's common that you've testified for a number of times. Ultimately, though, I think it comes back to the rigor of the analysis, as Todd said, and you know, but it certainly won't stop people from, you know, exploring those types of areas, and it happens all the time. I think there's a saying in English football, when you can't play the ball, play the man, and we certainly see that frequently, you know, as an expert. So you know, they will, you know, when you're being cross-examined, you'll get you know, whatever type of cross-examination can work to paint someone as a hack. You know, rest assured, it's going to happen.
Well, that's very true. And there's a fantastic quote which I want to read out at the end of this session about the way that experts are viewed. But just sticking with you, Don, and pick up a question from Christopher Moja about the relationships between the expert and the client. There's not just repeat appointments, but between you and any client, really, and how that affects your independence. I mean, can you get too close to a client? And what do you do to prevent that happening? What do you do to preserve your independence and preserve your independence in the eyes of the court or the tribunal?
I think certainly you do need to be conscious of your relationship, and you know, if you are hired on, you know, by a firm on multiple occasions, you've got to be conscious of that. And a lot of times the perception of a conflict is worse than the actual conflict. And, you know, so you need to be very careful about it. You know, but I think it comes back to something that I said earlier, which is that initial discussion where you have to have with your client that, you know, if I if I take one aggressive point in the report, it's gonna, that's where they're gonna spend the bulk of their cross-examination, and you lose on that point, you lose your credibility, and the rest of the report goes out the window. So, I think it's establishing that relationship with your client, irrespective of how many times they hire you.
And there's a question here from Charles Lazarovich saying, should an expert disclose the volume of work from the party that engages them over recent years, and whether their fees are fully paid up to date? I mean, that's an interesting question wearing your business hat.
I certainly think that, someone might find that interesting. I think on some of the jobs that you work on, the size of the fee can be very, very large because it takes many, many, people to do some of the work on some of these large mega projects. So, I wouldn't have a problem disclosing it. The clients may, but I think you've got to put those things into perspective as well, though.
Thanks, Don. Can I come back to Todd now for the question from Rodolphe Ruffle? Ruffle. Have the panelists noticed any difference of approach to the role and or style of experts, depending on their nationality or the nationality of the arbitrators? So bringing in the cultural side of this, what do you see amongst experts across the world?
That is a good question. I was listening when Don mentioned that experts in England, in the UK, I would add Canada, Australia, tend to be extremely circumspect and careful about their duties to court. I have seen experts from other places, other legal cultures, being less careful in being even-handed. That's true. And I guess they play to the audience. If you have international tribunals with members of the tribunal from European places, they may not have the same expectations about the rigor and care and balance that's required of experts in front of the English style tribunals. But I find also you have another class of expert, the ones who are very, very experienced. I came across an expert not long ago who had testified according to his CV 99 times. And I find these types of experienced experts are often slightly positive, slightly partisan, but in very subtle ways. And I think this is the real key problem. When you have gross partisanship, it's easily seen and easily cured. It's the subtle partisanship which is really problematic. And that's the one that's the toughest to address, I think.
Thanks, Todd. Should we move on to two questions actually from William Horton and Daniel Gianocchi? And perhaps I can come to Lynne for these. And these questions, I believe, about what should be the attitude of arbitrators and judges towards experts, and in particular, how during a case, how should a judge or an arbitrator use the expert? So Daniel says, what should a tribunal do to get better use from the party's experts? And at the other side of the scale, we've got William Horton, who said, well, is it wise for a tribunal to exclude expert evidence on the grounds of partisanship, or does it just come down to questions of degree and weight?
I think that's a really great question. What can judges and arbitrators do to make use of experts? I think certainly my experience has been that in arbitrations in particular, arbitrators, they have a way in during the course of the arbitration to themselves ask questions, to perhaps ask that the experts be directed to deal with certain assumptions in the joint statement, for example. They have often a kind of wider view of what's going on in the evidence and in the submissions the judge would have available to them. So that's something that they can do at an early stage, but actually hearing themselves, of course, judges and arbitrators have the opportunity to ask questions themselves of the experts. And what's interesting to me is that the extent to which a judge or an arbitrator will ask questions of their own of the expert, it really varies hugely. And that could be a very effective way of cutting through any perceived bias that there may be, or partisanship, because you'd expect the arbitrator and the judge to be able to get a more straight answer to their question than perhaps a barrister who's cross-examining might, because the expert witness may already be in defensive mode when they're being cross-examined by the other side's barrister or lawyer. Whereas when a judge or an arbitrator asks a question, they may feel, well, they've got to answer this in a straight way. They also may feel less inclined to believe that it's a question that has a spin to it. So I think there's a lot that arbitrators and judges can do to get to the heart of the issues by asking questions directed very specifically at certain assumptions, certain issues, and getting the answer that they want, rather than just leaving it to the barristers to cross-examine. Although, of course, I wouldn't want to encourage the judges and arbitrators to do too much of that, because that's part of the fun, isn't it, of being a barrister? So.
Absolutely. We're approaching the hour, so we have to wrap up in a second. But I can't, because I feel as if he's been ganged up on during this seminar, I have to come back to Don for a last word here, if anything really likes to say. But and specifically, Don, I'd be really interested in your views on how you think the expert witness world has changed over the last 20 years and is changing into the future.
I'm not sure there has been, an enormous amount of change. I think the focus on independence has probably become more acute. So if there's one change, which I think is probably a good thing, I think the more independent opinions are the more effective opinions, and so I think there's more of a focus on that. So I think that's probably a change that's occurred. I think when Adam started and mentioned all the cases, I think that's positive movement. I think in the industry, I would challenge all my experts and my colleagues to make the opinions as independent as possible. There is still a fair amount of partisanship out there, but I will. I think the last word, I will challenge the legal industry to come up with some better guidelines in relation to what a conflict of interest is for experts. I think it's different than a law firm. And I think it's different than a QC, but we kind of fall in no man's land. I think during the Court of Appeals hearing, the Court of Appeals said, look, there's not a lot of precedent guidelines here, and that's something that is an industry we should work towards.
Thanks, Don. And that's a very good note to end on. I'm actually going to end on in this quote in a second. But before I do that, I'd just like to thank Lynne, Todd, Adam, and Don for this very engaging discussion and all their views. It's been an entertaining session for my part. And I do want to thank the audience for all their questions. We've had 37 questions, and we barely scratched the surface, I think, on those questions. We could have gone on and on. So just to finish up, I just want to read out this quote because I think it sums up quite nicely some of the relationship between lawyers and expert. It comes from an essay by Professor Gross, who's at an American university. It's from one of an article he wrote about experts' evidence. He said, reading the comments of lawyers and judges, it is easy to get the impression that expert witnesses are intruders who disrupt the judicial search for truth. This is false, of course. As Carl Menninger pointed out, the expert is not self-invited to these parties. He's not a trespasser. He is called, then he is questioned, criticized, disputed, attacked, suspected, disregarded, and ridiculed. The expert witness that lawyers vilify is a creature of their own creation. Which I think is a fantastic quote. It sums up very nicely the relationship between lawyers and experts. With that, as we approach 7 o'clock, thank you very much and good evening.
Thank you. Good
Thank
evening.
you.